Good morning, this is your Kelso Report for Wednesday, August 17th, and I'm your host, Clark Kelso. We begin today with a Section 1983 claim for damages brought against a police officer, police department, and municipality as a result of an unconstitutional search of a personal computer for child pornography. Section 1983 claims against local government and local government employees are very difficult claims to win, because of a number of fairly high hurdles the plaintiff needs to clear right at the beginning of the litigation, even before the merits are joined. As we will see, the plaintiff in today's case was not successful, even though the court held that the plaintiff's constitutional rights had been violated, and even though the search did not uncover any child pornography, which was its intended target. In today's case, Doherty v. City of Covina, the Ninth Circuit held that a police officer who conducted a search of a 6th grade teacher's personal computer for child pornography, pursuant to a search warrant that was unconstitutionally issued, nevertheless was shielded from liability under Section 1983 because of the doctrine of qualified immunity. The court also rejected the plaintiff's claims against the police department and municipality on separate grounds. Let's deal with the qualified immunity issue first. A police officer is not entitled to qualified immunity if 1. The facts show that the officer's conduct violated a plaintiff's constitutional rights, and 2. Those rights were clearly established at the time of the alleged violation. According to the court, the search warrant in this case was improperly issued because the affidavit in support included only a 3-year-old allegation of attempted molestation by one student and current allegations of inappropriate touching of and looking at students. Joining the 2nd and 6th Circuits, the majority held the evidence of possible child molestation and current allegations of touching were insufficient by themselves to create probable cause for a search warrant for child pornography on the target's personal computer. However, qualified immunity still applied because the Ninth Circuit had never previously addressed this question, and the 8th Circuit had rejected the reasoning of the 2nd and 6th Circuits. In these circumstances, with the law so unsettled, the plaintiff's rights were not clearly established at the time of the alleged violation, so the police officer received the protection of qualified immunity. As for the claims against the police department and the city of Covina, recall that a local government entity may not be held liable under Section 1983 unless a policy, practice, or custom of the entity can be shown to be a moving force behind the violation of constitutional rights. That is because, under the leading case of Monell v. Department of Social Services of the City of New York, there is no vicarious liability under Section 1983. So the department or city can be held liable only for their own policies and practices. The best the plaintiff could do in his complaint was to allege in very conclusory fashion that the search warrant was issued pursuant to police policies and practices, and in particular, that the department's failure to train and supervise led to the unconstitutional warrant. Unfortunately, the complaint lacked any factual allegations that would separate the complaint from a formulaic recitation of a cause of action's elements. And a formulaic recitation is insufficient to sustain a complaint under the Supreme Court's decision in Bell Atlantic Corporation versus Twombly. The complaint needs to include factual allegations demonstrating that the constitutional deprivation was the result of a particular custom or practice, and the plaintiff's complaint did not contain those allegations. So the complaint was properly dismissed by the trial court. As I said at the start, these are very difficult cases to win. Our second featured case, Barretes v. Murray, resolves an important procedural question that has divided California's appellate courts over the years. CCP Section 660 plainly says that after the lapse of 60 days from entry of judgment, quote, the power of the court to rule on a motion for a new trial shall expire, close quote. Now, this 60-day rule works just fine at the trial court level when a final judgment has just been entered, and the goal is to make sure that a decision on a motion for new trial is made promptly. But how does that 60-day rule apply when an appellate court decides that the trial court on remand should make the decision about whether to grant a new trial? This can happen, as it did in Barretes v. Murray, when it is clear to the appellate court that the trial court used the wrong legal standard in denying a motion for new trial. In Barretes, the trial court erroneously believed that it actually lacked power to order a new trial, where it disagreed with the jury's credibility determinations. In fact, it is perfectly clear that the trial court, in ruling on a motion for new trial, has the power to disbelieve witnesses, reweigh the evidence, and draw reasonable inferences contrary to those of the jury. So the appellate court needed to reverse and remand so the trial court could reconsider the motion for new trial. But what about Section 660? Well, 3 courts of appeal in California have held that Section 660 is jurisdictional, and that because of the lapse of time, the case cannot be remanded for a new ruling by the trial court on the new trial motion. Instead, in these cases, the court simply reversed the judgment, and the case is ultimately reassigned, usually to a new judge, for a retrial. This is not a particularly efficient use of judicial resources. So to avoid that result, the Second District in Barretes v. Murray interpreted Section 660 as applying only in the context of a trial court's consideration of post-judgment motions before there has been an appeal. Once there has been an appeal, and the issue relates to consideration of a new trial on remand, Section 660 simply does not apply. And now our one-liners. We have 3 of them today. The first in the area of criminal procedure. In People v. Meza, the Second District held that the prosecution's failure to allege in an information that a prior prosecution against the defendant for selling heroin had been pending for several years, thereby tolling the applicable statute of limitations, was a, quote, minor error of omission, ambiguity, or technical defect, which can be expeditiously cured or corrected without a rehearing of a substantial portion of the evidence, close quote. That's quoting Penal Code Section 995A. As the court explained, although the missing evidence here technically prevented a finding of probable cause to hold the defendant over for trial, it did not go to the heart of the case, and the evidence actually offered at the preliminary hearing was sufficient to establish each element of the charged offenses. Accordingly, the trial court's order granting the defendant's motion to set aside the information under Section 995 was reversed, and the appellate court remanded for further proceedings to determine whether the additional information the prosecution sought to offer shows cause to believe that the proceedings are not barred by the applicable statute of limitations. I have a feeling the prosecution's going to get it right this time around. Next, an arbitration case. In Templo Calvario Spanish Assembly of God versus Gardner Construction Corporation, the 5th District held that the trial court erred in vacating an arbitration award involving breach of a construction contract on the ground that the contractor was unlicensed, and the construction contract, which contained the arbitration clause, was therefore illegal and void. The trial court had relied upon a 1949 California Supreme Court decision in Loving and Evans versus Blick, which declared that such a contract was indeed illegal and void. That's how they did things in 1949. Well, the 5th District held that Loving and Evans was no longer good law in light of the California Supreme Court's 2005 decision in M.W. Erectors, Inc. versus Niederhauser Ornamental and Metal Works, where the court squarely held that such a contract was not automatically illegal and void. In particular, the court in M.W. Erectors held that even if the contractor did not have a license at the time of entering the contract, nothing in the Business and Professions Code prevented the contractor from suing for compensation under the contract, so long as the contractor subsequently had become licensed. Thus, the contract was not illegal and void. Relying upon M.W. erectors, the 5th District concluded that there was no compelling need to conclude that the state contractors law mandates that a consumer cannot proceed to arbitrate its dispute with a contractor simply because the contractor was unlicensed at the time of signing the construction contract. The consumer has the power to go forward with the arbitration. Next, in the area of employment law. In Rogers versus County of Los Angeles, the 2nd District held that an employee who was out on medical leave for 19 weeks could not maintain a claim for interference with her rights under the California Family Rights Act based on the county's decision to transfer her to a different position, since the Act gives employees only a maximum of 12 weeks of leave. Her claim for interference expired when she did not return to work after 12 weeks on leave. She also had a claim for retaliation under the Act, and that also failed as a matter of law because of lack of substantial evidence that her leave was a motivating factor for the transfer. In fact, the evidence showed that the reorganization of her office and her transfer was being discussed before she began her leave, and the transfer was authorized only 1 month into her leave. And it had nothing to do with her. It was just an ordinary office reorganization. Although the transfer was not communicated to her until her actual return to work some 4 months later, the court held as a matter of law the county had a legitimate, non-discriminatory reason to transfer the plaintiff, which had nothing to do with her medical leave. And that's it for today's Kelso Report. I'm your host, Clark Kelso. Have a great day in the law.